All right. In the interest of everyone's time, we are going to go ahead and get started. Thank you for being here this morning for our Leader to Leader session on Title IX regulations. So before we begin, a couple of reminders. Use the Q&A system to pose your questions, and then you have the option to upvote questions if you want to make sure those are answered. So voting on those questions that you may have the same questions on. We ask you to use the chat to add ideas and or comments, making sure that's set to everyone so that we can all see that and interact. A copy of the slide deck, as well as a link to the recording of today's session, will be emailed to everyone and distributed in our future publications. Most likely it will be in our headlines, which go out on Monday. So a couple of reminders as well, just to note that this session is being recorded and it will be posted for public viewing. The information provided by MASSP as well as our panelists is advisory in nature based on information as of today's date and intended to guide your thinking. We, as always, principals, we advise you to seek specific guidance in any of these areas from your district leadership, legal counsel, and local law enforcement. If you're seeking a thought partner to help with brainstorming or planning, please contact any member of the MASSP team. We strongly recommend that decision makers work in collaboration with your district leadership, teachers, students, leaders, and their Board of Education based on the most current information available and local capacity. So there's my long disclaimer that I have to give there. So without further ado, I am going to introduce and hand over slides, capability and all of that to Jessica McNamara, and she's with Thrun Law Firm, one of our partners. We thank you for being here today and sharing information on this important topic and the new guidelines that came out this year.
Absolutely. Okay, let me attempt to share my screen. Everyone bear with me as I do this. All right, let's see. Does this one work? All right, all set? Perfect. Okay, so let's chat about Title IX, right? I mean, I feel like since 2020, everything kind of got flipped upside down, right? And so since 2020, it's really been on our radar and how it's sort of shifted in our thinking of Title IX. It shifted from, the concept of equity in athletics to sexual harassment. Well, now we're in 2024. It's a new presidential administration than what provided us the 2020 regulations. So let's chat about what you need to know as building principals and making sure that your colleagues, your students, everyone is getting the support that they need, and that's now required under the new regulations. So I do have a few cautionary slides simply because this is what we're dealing with. And one is to acknowledge that these things can change, right? There's a lot of litigation going on right now. I'll actually talk quite a bit about it because those are the questions we're getting the most. And so because of that, future legal developments could affect these topics. So please take everything I say today with a grain of salt. Obviously, what's true for today, September 25th, 2024, may not be true come December 1, 2024. Who knows? And then the other thing to keep in mind as well is that under the Title IX regulations, there is a requirement that you receive very specific comprehensive training if you're going to serve as your district's Title IX coordinator, investigator, decision maker, or informal resolution facilitator, and the appeals officer. This training today, this presentation today, that doesn't satisfy all of those requirements, so please keep that in mind. Okay, so I know I have your time until about 10 o'clock today, but what we really need to focus on is the fact that this is a really fluid situation. So back in 2020, right, the height of the pandemic, everyone's scrambling, trying to figure out what does school look like in light of COVID. And then Secretary of Education, Betsy DeVos, dropped new Title IX regulations on us. And those regulations became effective on August 14th of 2020. Now, almost immediately afterwards, there was a new presidential administration, and they came out and said, listen, We understand that there's these new regulations, but we're not a fan of them. So we are going to put together our own regulations, and we'll keep you updated. So fast forward 2 years later, in June of 2022, they sent out a notice of proposed rulemaking, which is essentially a requirement for them to say, hey, we're planning on changing up these Title IX regs. Stay tuned. Here's what we anticipate them looking like. When those went out, over 240,000 public comments came in to the Biden administration's proposed new rules. And so what is required by federal law and when they go through and make these new regulations is they have to go through, view each public comment, and actually respond to those public comments. So that's why it takes so long. So what this means is that even though the notice of proposed rulemaking, the proposed new regs came out in 2022, in light of the fact that there were all these public comments, they didn't release them and properly respond to all those comments until almost 2 years later, which was April of this year. On April 19th, they released the 2024 regulations and said, we're giving you until August 1 to pull everything together and put them into, and that's when they will take effect. Well, as I think many people suspected, when those new regs came out, there were a lot of opinions. I think that's the best way to put it. And initially, there was a Louisiana court that said, you know what, we're going to go ahead and issue an injunction, meaning we're going to say for the state of Louisiana, Mississippi, Montana, and Idaho, we're going to grant your request for an injunction, and these regulations we're going to halt the implementation of these regulations. That was in June of 2024. 3 days later, on June 17th, 2024, a Tennessee court also issued an injunction that applied to Tennessee, Kentucky, Ohio, Indiana, Virginia, and West Virginia. And then about 2 weeks later, there was a Kansas court, and they also issued an injunction to Kansas, Alaska, Utah, and Wyoming. Now, I know that we're in a presidential election season, so we're very familiar with the concept of red states and blue states. And if you look at the states that there's currently an injunction for, if we looked at a presidential election map, all of those would be colored in red, right? They are Republican states that have a Republican attorneys general. And those were the ones that were challenging these decisions. So here at our office, we knew that in Michigan, we have a Democrat that is currently serving as as our attorney general. So we knew it was more likely than not that she would not be challenging these regulations. So we've safely kind of assumed Michigan's not going to challenge these regs. They'll become effective August 1. But what happened on July 2nd is the Kansas court said, yes, I'm issuing an injunction for the state of Kansas, the state of Alaska, Utah, and Wyoming. I'm also issuing an injunction as it's applicable to schools that are attended by the members of the Young America's Foundation, the Female Athletes United, as well as schools who are attended by children of the members of Moms for Liberty. And so all of a sudden, we have this injunction that doesn't apply statewide to a particular, besides the few that I mentioned, but it could apply if you have kiddos in your school whose parents are members of Moms for Liberty. So all of a sudden, what we kind of assumed would be, not an issue that we had to deal with here, suddenly became our problem. So what the court said is, listen, we understand that Moms for Liberty is a national organization, but we're going to put the onus on them and say, you have to identify and file with the court a list of schools where your members' children attend. And so on July 15th, here at the office, we're all expecting a pretty lengthy list. Well, on July 15th, they published it. And these were the only schools that were listed. They were not very many. And more importantly, a number of them were actually private schools that don't have to follow Title IX anyway. So we were really actually quite shocked. But what was fascinating is the court said, okay, you're right. We'll make sure that this injunction applies to those school districts as well. But, Moms for Liberty, if you need more time, we'll give it to you. And you can supplement your list. And so they went on to say that basically the court concludes that all of the plaintiff's organization members, current and prospective, are entitled to this relief that's ordered by this court. The court's order regarding identification of affected schools was the first step in ensuring that defendants have notice on that point. Supplements to the original notice may be appropriate as the case progresses. As a result of this ruling, Moms for Liberty is granted until July 26, 2024 to file a notice of schools attended by its members' children. Okay, so we're like, okay, they can supplement it one more time. Well, the court went on to say, actually, we're going to let you supplement it as many times as necessary. So here we are. So far, we have had 5 total lists. There's a list that came out July 15th, July 26th, July 31st, August 28th, and just a couple weeks ago, September 13th. Now, I will say this. The one on September 13th really just tweaked the legal names of a lot of the districts that were on that list. What I anticipate moving forward is chances are that this list will be supplemented monthly. So it went July 31st, then August 28th. I think that we can expect another one probably towards the end of September or early October. So what that means is that if your school is on the list, the injunction applies to your school. But what does that mean? Well, let's first focus on what the bases for those injunctions were. One is that they said, listen, back in 1972, when Title IX was first enacted, there was, and they used discrimination on the basis of sex. That language, as initially enacted back in 1972, was understood to be a binary concept, right? Back then, everyone agreed that it was male and female. And so you have to rely on the plain language of the actual law. Well, again, you can have a disagreement and have a policy argument about which side you believe in, but that was the basis for the initial injunction. In addition to the fact that they said, hey, Department of Ed, these new regulations change a lot. They alter our obligations, they expand the scope of who Title IX applies to, and you don't get to make legislative decisions in the executive branch. So this was not something that you were permitted to do. And it also talked about how these 2024 regulations often, they speak about sexual orientation and gender identity, and that if you are criticizing or harassing someone based on on someone's sexual orientation or gender identity, you could actually be chilling free speech, and that's not permissible. So those first 3 bullet points, like I said, those are policy arguments, right? And you're going to have people on both sides of the aisle arguing for or against those ones. But as we'll talk about later, this 4th reason why they granted the injunction is because the new definition of hostile environment, the court said, is ambiguous. Now, I want you to actually think about this 4th bullet point as we go through and talk about that definition, because I know that I've read the new definition of hostile environment, and I agree. It is pretty ambiguous. And the question is, do we know how to apply it? And do students know how to apply it? And that's what the court would be looking for. So those were the bases for that injunction. Now, here's the thing. What the injunction does and what the common misconception is they think the injunction means that schools are prohibited from putting in place the 2024 regulations. That's not true. Despite what a parent may say, despite what a local member of your Moms for Liberty group may say. What the injunction did was say, OCR, you're prohibited from enforcing the 2024 regulations on these schools. Schools, you still have discretion as to how you implement your Title IX regulations, how you implement and address sex-based harassment. We still have that authority. And the court even acknowledged this and said, listen, you schools, you have the ability to adopt and follow your own policies and or otherwise comply with applicable state or local laws or rules regarding the subjects addressed herein. Meaning that if you want to adopt the 2024 regulations, you can. If you want to continue with the 2020 regulations, you can. But OCR doesn't get to come in and yell at you for lack of 2024 compliance if you're on one of those lists. You know, the Department of Ed, they have not backed down from the court. They said, listen, we stand by our final Title IX regulations that were released in April of 2024, and they will continue to fight this matter in court. What was interesting is that in 2024, OCR actually issued some, in July of 2024, OCR actually issued some guidance. And they said, listen, we're aware of all of these court's rulings, but at the end of the day, we believe that our regulations, those are going to apply to every single school that's not on this list. So it's not like we're going to back down and revert to 2020. On August 1, when the regs took effect, OCR actually supplemented its guidance and said, if your name, if your school is on the list, whether your state's on the injunction or your school here in Michigan is on the list, OCR's expectation is that further pending court orders, you need to keep in place your 2020 regulations. So it's not like these injunctions are get out of jail free cards for Title IX. You still need to process your complaints. OCR says if you're on the list, then you're out of luck. You have to stay with 2020 in that onerous process. So what does this mean? Okay, August 1, our regs are effective. If you don't have a school that is on one of your Moms for Liberty lists, and make sure it is actually on the list and not just a Moms for Liberty member insisting they're on the list, double check. If you have a school that's on the list, you need to apply or you need to have in place your 2020 regulations. If your name is not on the list, you are required to have your 2024 regulations in place. But let's break this down a little bit further because it's really not that clear cut when we really dive into it. I will say this, one thing is clear cut. If your school district or your school building is not on the list identified by the court, you must adopt and implement Title IX regulations that are consistent with the 2024 regulations. If your name is on the list, right, then we have a couple approaches. One, according to the court, you actually have the authority to continue to move forward with your 2024 regulations, right? Now, we recommend that you archive your 2020 policy. We don't want you to completely get rid of it. Hold on to that. But the question then becomes, you do have the ability to just revert back to your 2020 regs. Now, keep in mind that if that injunction actually goes away, then you immediately need to put in place the 2024 regulations. So we recommend that you immediately adopt your 2024 regs, and then you can make the decision if your name is on the list, whether to follow 2020 or 2024. Yeah, I have a raised hand. Yeah.
Thanks, Jessica. I just wanted to ask, when we send out the links, are you able to provide that list that I can attach with the email?
We can provide you a link to the list because those lists aren't cumulative.
Yes.
So we basically have 5 separate documents that we've
Okay,
compiled into a single PDF. So yes, I will work on compiling those and make sure you can have those as well.
perfect. Thank you for that.
Now, if you notice this third bullet point, it does talk about how the 2024 regs, you can put them in place, but there is some risk. The reason why I say there's some risk is because OCR did say, hey, if your name's on the list, you have to do 2020. I personally believe that I don't think OCR is going to come after a district if it chooses to go and actually implement the 2024 regulations, because quite honestly, those are the regs that OCR wants you to implement. But the court said OCR can't force you to do that. OCR can, however, force you to have 2020. So really it is just, you're going to have to weigh the risks and benefits as to what to do. Now, the reason why we want to make sure, even if you've chosen to go down the 2024 path, or maybe you're required to because none of your schools are on the list, we want you to archive your 2020 policy because these regs are not retroactive. So any complaint that comes in before August 1, or excuse me, any complaint that alleges conduct that occurred before August 1, the 2020 regs apply. So we want to make sure that we have that. And another thing to keep in mind is that what is it about these lists that really prompted that injunction, right? It wasn't the process. I think everyone was really excited that it was going to be a more efficient process when we were handling allegations of sex-based harassment. But what prompted it was the definition of sexual orientation and gender identity or expression, and how that was included in the definition of sex now under federal law. What's interesting here is, though, we already had to operate that way under state law. So unlike Title IX, here in Michigan, remember Title IX is federal. Here in Michigan, we already had a law on the books that said sex includes sexual orientation and gender identity. So it's not like we got to ignore harassment based on those things in the first place, right? So really, in the injunction itself really doesn't alter our obligations here in Michigan, because we already had to ensure that discrimination based on those concepts were not occurring. So a few things. If your name is on one of those lists, make sure that you understand from your board what approach they want to take, right? What is your superintendent directing your schools to do and how to operate? It's going to be a board decision. I double check to see what Title IX policy you guys have on the books. And then I'd also encourage you to chat with your title or your board policy folks and say, listen, I know a lot of people are upset about these 2024 regs based on the definition of sex. And that's fine, right? They have that right. That'll be battled out in courts. But one of the advantages of the 2024 regulations is it made everyone's life easier when it came to actually conducting the investigation. And I'll show you why here in a minute. So let's talk about the legal landscape, right? So that last 25 minutes was just how in the heck did we get to where we are today? And what does this look like moving forward, right? And it all boils back down to, this is all based on one tiny sentence that was enacted back in 1972. And that simply says that no person in the US shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity that receives federal funds. What was our timeline, right? 1972, Title IX was enacted. 2 years later, the first regulations went into effect, and those were the regulations we operated under until 2020. In 1997, OCR came out with a decision that said, listen, schools, you need to respond to sexual harassment allegations. And that was really the first time we kind of put it on our radar that sexual harassment actually falls under Title IX. It's not just about equity, right, and inclusion, but a subset of equity and inclusion for all sexes is ensuring that there isn't sexual harassment. A year later, the Supreme Court, they actually issued their first employee to student Title IX matter. And that's when they said, hey, schools, if you act in, if you're deliberately indifferent, you could be liable for money damages. The following year, they did the exact same approach and said, listen, when it comes to student misconduct, you could also be liable if you're deliberately indifferent. And then in 2020, right, that's when we got our regs. And then again, 4 years later, new presidential administration, we've got our new regs that we're dealing with now. A few things to keep in mind. These regs, they became effective on August 1 and they're not retroactive. Always keep your 2020 policy on hand because it's the start of the school year. I know I'm currently processing plenty of investigations of things that happened over the summer. That means we're applying our 2020 policies, even though, and even if your school is not on one of those lists and you have your 2024 policies in place. Also, these regs, they slightly broaden the jurisdiction. They say, yes, of course, we have to address sexual harassment and sexual or sex discrimination within our program or activity, but we may also have to address it even if it occurs outside of our program or activity, if it's contributing to a hostile environment. So one thing these regs did is they actually broadened the scope. So remember how in 2020, the focus was sexual harassment, right? And here's how you have to process it. Now, these new regulations say, yes, of course, we need to address sex-based harassment, but we are also going to be addressing the broader umbrella of sex-based discrimination for staff and students. So what does that mean? It means that we need to address discrimination based on sex stereotypes, characteristics, pregnancy or related conditions, sexual orientation, and gender identity. So what were some of those key changes that we've seen, right? What really do you need to keep an eye out for? First is, like I said, it broadens the scope. It applies not just to sex-based harassment now, but also sex discrimination. If someone complains about your baseball field compared to your softball field, Title IX, these regulations now apply and how you process those complaints. Now, you also need to, it also now includes discrimination based on pregnancy, sexual orientation, and gender identity. All of those things are now included. It modified how certain employment practices, and now finally we can return to our single investigator model. Gone are the days where you need to have a Title IX coordinator, investigator, decision maker, appeal officer, and informal resolution facilitator. Now, under the new regs, you could have your Title IX coordinator could also serve as the investigator and decision maker. It does provide some more local control, so make sure you're really familiar with your own board policy on this. It will specify certain timelines. All of those things, in 2020, it was a very specific process that every single school had to follow. Now we have a little bit more leeway. It did, however, remove the right for someone to have an advisor or attorney of their choice. Training needs to be aligned to your local grievance process. So like I said, if you serve in one of those key roles, this training is not sufficient, but that comprehensive training needs to be specific to your actual grievance process as well. So what hasn't changed, right? What is going to continue to be the norm? One is every single staff member, everyone that's inside your building, they have a staff reporting obligation. If they see something, they need to say something. Our respondents are also presumed not responsible. And then there is limitations on student removal. This one is so important and the piece that I see violated the most. We do not get to remove a student. simply because there is an allegation that they have engaged in sex-based discrimination or harassment. Even if we have a video clearly identifying that they've done it, we have to run the Title IX process before we can get to the end. There are still significant training and record retention requirements. That hasn't changed. It's just slightly tweaked what needs to be trained. And then also there is still liability if we fail to respond promptly and appropriately. So I talked about pre-employment inquiries. So remember, Title IX now, these new regulations, it's not just sex-based harassment, but any form of sex discrimination that could occur. And they also have certain very specific requirements. Now, if you at your building level, say you're sitting through an employment interview, you're looking at bringing on a new janitor, you're looking at maybe hiring a new parapro, and you're going through those interviews. You can no longer inquire as to someone's marital status, including whether the applicant is a Miss or Mrs. So it is make sure that if you have an application form and it has, might have a box that says Miss, Mrs., Mr., and then they write their name, that's no longer allowed under Title IX. So you likely need to revise your application forms. Also, you can only ask about sex if you do so for everyone, and the response isn't used as a basis for discrimination. So you are allowed to ask, for example, to everyone, what are your preferred pronouns? Obviously, you can't do that if the goal of that question is to then discriminate against someone. But that is something that is still permissible. It also addresses sex separation, right? And it says, listen, Title IX has always stood for the fact that you can provide separate toilets, locker rooms, shower facilities based on sex, but they need to be comparable, right? That makes sense. The boys' locker room can't be a lot nicer than your girls' locker room. And you can provide separation, on certain objective criteria for certain classes. But generally speaking, separation based on sex for athletics is not prohibited unless it's a contact sport. Now, again, Michigan has a law on the books that says any female student has the ability to apply to or try out for the male team. So that one is a little different here in Michigan. And then also you always need to consider whether there is disproportionate enrollment based on discriminatory counseling. Say you have a strength and conditioning class and it is 95% guys. You need to make sure that the reason why it's 95% guys is not because your counselors are saying, you don't want to do that one. We have art instead that hour, or we have, a Spanish class that hour. That's the guys' time, right? Make sure we don't have that happening. And then, of course, adopting a policy or engaging in a practice that prevents someone from participating in a program or activity consistent with the person's gender identity is prohibited. So what that means is that if we adopt a policy or engage in a practice that prevents someone to do something simply because of their gender identity, that is not permitted under Title IX. So let's chat about athletics. We were supposed to have a separate athletic regulations under Title IX. They kept on saying that they were still working on it. It wasn't because of the upcoming election that they were delaying it. But I think we can all see through that and recognize that when it comes to athletics, this is a really hot button issue. And quite frankly, it's an election year. And so I don't anticipate that we will have these before the election. But these regs do say, they do briefly touch on athletics. And it says, listen, you can have separate teams based on sex, so long as selection is based on competitive skill or activity. Members of the opposite sex may have a right to try out unless it's a contact sport. You need to provide equal athletic opportunity for members of the both sexes. And like I said, Michigan law, it's a little different than Title IX. We actually have a law that says girls can be allowed to compete for a position on the boys' team. Now, pregnancy protections. This is new to Title IX. It specifically addresses it. And it says you can't treat individuals differently based on current, past, or suspected parental, family, or marital status. And you can't discriminate based on pregnancy or related conditions. You need to make sure that they have equal access. We're making reasonable modifications for students, reasonable break time for lactation, and a lactation space for both students and employees. We need to make sure that our basically any pregnancy or related condition are treated the same as any other medical condition. And we can't just ask for doctor's notes. So please be very careful as you deal with your students and your staff members who are pregnant. So when I say related conditions, that's defined by the regulations to say childbirth, termination of pregnancy, lactation, a medical condition related to any of the above, and recovery from any of the above. All of those things are now addressed under Title IX. This is where I want to make sure all building principals are aware of this new requirement and you let your staff know of this new requirement. Under these new regulations, once a staff member learns that a student is pregnant or has a related condition, the employee must let the student know the name and contact information of the Title IX coordinator and let them know that the coordinator can coordinate actions to prevent discrimination. There is an affirmative obligation for every single employee to do this. So if you have a staff or if you have a student that goes up to a parapro or a hall monitor, and they say, I took a pregnancy test last week, it's positive, I'm worried about what mom or dad might say. That employee is now obligated under Title IX to say, listen, here's our contact information for our Title IX coordinator. They can help chat with you about, ensuring that you're not subject to discrimination at school. What I want to make sure, though, is that conversation stops there. We do not want our employees counseling students on these matters, right? We don't want to then say, here's our Title IX coordinator, and down here is Planned Parenthood, and over here is, a housing for unwed mothers. That is not the employee's job. Their job under Title IX is to simply provide contact information for their coordinator and to let them know that the coordinator can help ensure that no discrimination happens. The second we allow our staff members to go further, we start walking into big issues. Yes.
Jessica, we have a question from Melissa. She says, if we require a doctor's note for all students when initiating or providing homebound services, can we require a doctor's note for pregnant students? And she goes on to say, our auditors required a doctor's note to support homebound instruction.
Yes. So homebound is a separate and distinct pupil accounting matter. And that does require a note from the doctor that the student will be out for, I believe, at least 5 school days. Maybe, I think it's 5 school days. Don't quote me on that. We cannot require that here. So I would say that if you have a student where you just, maybe you're a little concerned that the student may not be truthful in what they're telling you, my response would be, don't take a gut reaction of forcing them to go get a doctor's note saying they're pregnant, or undergoing a pregnancy related condition. Call legal counsel. Let's talk through our options, because I don't want to walk you guys into a landmine when you're trying to do the right thing. Okay. What are some additional obligations? So we need to make sure that there's notice to the student or parent / guardian of non-discrimination obligation, that reasonable modifications, we're willing to make those reasonable modifications to our policies to ensure we have equal access. Now, keep in mind, we can offer these, we can't force them, meaning we can absolutely offer up a certain lactation space for a student, or we can allow them the opportunity to go online. But if that student says, I don't want to go online, I want to stay in class, we can't force them to go online. And of course, we always need to make sure that they have access to the same programs and activities as they always would, and recognize that we may need to allow a voluntary leave of absence for both our employees as well as our students when it comes to these matters. Always make sure that they have access to a lactation space that is not a restroom and that is clean, shielded from view, and free from intrusion. So, what are some key Title IX roles? This is going to be something that's very similar to what we've always had. We need to make sure we have our Title IX coordinator. It needs to be a district employee. Investigator, decision maker, appeal officer, an informal resolution facilitator. All of those individuals can actually be someone that is not an employee. The one exception to this now is students actually have the right, and employees have the right, to challenge supportive measures that they are being offered. Any challenge to a supportive measure needs to go to an individual that is actually a district employee. So your Title IX coordinator, right? It needs to be an employee. You can have more than one. In fact, we usually encourage that if you have sufficient staff, you have more than one. But Title IX now requires that you identify someone with the ultimate authority on the oversight and compliance. So in the office, we joke that you need a super coordinator, right? Get them a cape, get them a special costume that they get to wear. But essentially, you need to identify someone that says, listen, this is our ultimate main coordinator, but these other individuals also can serve as the Title IX coordinator. Coordinators still have the ability to initiate complaints, even if the complainant does not want to. And your coordinators are required to make sure that everyone complies with Title IX within the district, and that they are taking steps to address and remedy any potential discrimination. So let's get back to what sexual harassment now looks like, right? So a few things have changed, mainly that being the definition of hostile environment. These 3 bullet point definitions should look familiar, right? Quid pro quo harassment, hostile environment harassment, and sexual violence harassment. All of those were similar from 2020. Quid pro quo, right? This is if a district employee, agent, or person who's able to act on behalf of the district is explicitly or impliedly conditioning aid or service or benefit on this person's participation in some sort of unwelcome sexual conduct. So this is your typical, if you go on a date with me, I'll give you a promotion, right? That's what quid pro quo is. We honestly don't see that very often. And then, of course, we have our sexual violence definitions: sexual assault, dating violence, domestic violence, and stalking. I'm not going to go through each of these definitions, but one thing to keep in mind, that sexual assault includes forcible fondling. And forcible fondling is defined as the touching of someone's intimate body parts, clothed or unclothed, for the purpose of sexual gratification. So what that means is that if you have someone who has groped someone's breasts or butt or genitals, that is going to meet the definition of sexual assault, and Title IX will likely be enacted. But let's chat about hostile environment. Remember, this is one of those bases for the injunction. Under 2020, we operated as a unwelcome conduct that a reasonable person would determine to be so severe, pervasive, and objectively offensive that it effectively denies a person's equal access to the school's programs or activities. Now, the new definition is still unwelcome sex-based conduct, but it's based on totality of the circumstances, and it needs to be subjectively and objectively offensive, and is so severe or pervasive that it limits or denies a person's ability to participate in the school's programs or activities. So now it needs to be both subjectively and objectively offensive. and it needs to be so severe or pervasive that it limits or denies someone's access to the programs or activities. This is a very bizarre definition. We're trying to figure out how it applies. I think it significantly expands what Title IX now applies to because of the use of the word or. We don't need something to be severe, pervasive, and objectively offensive. Now it just simply needs to be so severe or pervasive, and it just needs to maybe limit someone's ability, not just deny their ability. So all of those things make it to where it really does expand the definition. Now, we do have some guidance on this topic, and it does say it needs to be a fact-specific inquiry, and we need to consider the degree to which access is affected, the type, frequency, duration of the conduct, whether the parties' ages, roles, or previous interactions, the location to which it occurred, and maybe any other forms of sex-based harassment within the program or activity. We do still have kind of this outside obligation to address off-campus sexual harassment as well. And they noted that off-campus sexual harassment may eke on to the school and create a hostile environment. So keep that in mind. There is no bright line test as to whether we can address off-campus sexual harassment. You need to address it on a case-by-case basis. And you do need to make sure that you're investigating it if the school doesn't know where the misconduct occurred. Now, Title IX does say that we do need to address conduct that is subject to the school's disciplinary authority. Here in Michigan, we have a very unique provision of our revised school code, and that says that if there is an off-campus criminal sexual conduct between two district students, we may be able to impose discipline. So arguably, and we haven't really worked through this entirely here, and thankfully this issue has not been brought up yet, but arguably you may need to run the Title IX process for off-campus sexual misconduct if it occurs between two students. Now, please, please, please call legal counsel before you dive into that, because we really don't want everyone to have to be policing what happened in Susie's basement on a Saturday afternoon, right? That really complicates your role as educators. Okay, some more things to keep in mind. Reports and complaints. Formal complaints are no longer required. An oral complaint is sufficient to kick off your Title IX process. If someone has knowledge of conduct that could constitute sex discrimination, we need to make sure that that information immediately goes to your Title IX coordinator so that they can begin the process. Your policy will identify what your timeline is to make that report to your Title IX coordinator. Make sure you're familiar with it. Anyone who has a Thrun policy, it's within 1 business day. So keep that in mind. Your messaging to your staff, to your building needs to be, if you see something or hear something, they need to say something to your Title IX coordinator. Non-compliance could result in discipline. Now, one of the things the regs now allows is for you to identify a confidential employee. We strongly recommend that you do not do so. Keep in mind, Title IX applies not just to K-12, but also to universities. So there are some rules in there, some options in there that may make sense for universities, but don't make sense for us. We have a mandatory reporting obligation. So even if someone's designated as a confidential employee, if they receive information that may trigger their CPS reporting obligation, that report needs to be made. But more importantly, I don't want employees to think that they have the ability to withhold something from administration. At the end of the day, we want to make sure that if misconduct, sexual misconduct is occurring within your school building, it is appropriately addressed. So while confidential employees may be designated now under Title IX, I do not recommend that you do so. I briefly mentioned this. Complaints can be made oral or written. But again, either way, make sure it makes its way to your Title IX coordinator so that they can begin the process. These complaints, of course, are for sex-based harassment, sexual harassment, but also for sex-based discrimination. Really, if there's a concern about sex-based discrimination, the person who can initiate the complaint, and for this I mean locker rooms look different, or the counselor only ever enrolls the girls in art class. Those sorts of complaints can be made by anyone. It doesn't need to be made by someone who is the target or maybe the victim of that form of discrimination. Whereas for sexual harassment, that either needs to come from the complainant or their parent or guardian or the Title IX coordinator. Same with 2020, your Title IX coordinator, they can initiate a complaint even if we have an uncooperative complainant, or we have someone who is maybe just afraid to initiate that complaint. Your Title IX coordinator will be trained on when they should or should not initiate a complaint. But ultimately, even if you have a complainant that says, I don't want to do Title IX, I don't want to be involved, this is a bad idea, your Title IX coordinator gets that ultimate decision. This should not be a decision that is made at the building level unless you have a building level Title IX coordinator. I don't want building principals to inadvertently walk into a Title IX claim simply because they thought they were doing the right thing by agreeing with the complainant's wishes. Also, please keep in mind that when it comes to respondent removal, we don't get to kick them out. So building principals, make sure everyone is aware that if the student misconduct alleges something that falls under Title IX, we cannot place them out while we conduct the investigation. They have to be allowed to stay in. So immediately reach out to your Title IX coordinator so we can get this investigated as quickly as possible, so it can be handled as quickly as possible. There is one exception to this, and this is if there's an emergency removal, and that can only be accomplished if there's an individualized safety and risk assessment done, and there needs to be a determination that there's an imminent and serious risk to the health or safety of the complainant or others that arises from the allegations of sex discrimination. Now, this is a slightly easier threshold to meet than what we had in 2020 because there's no longer arguably if it could impact someone's emotional well-being or it's a threat to someone's emotional mental health, things like that, we may be able to remove. But again, I don't want you making that decision. I want you working in conjunction with your Title IX coordinator. Training requirements, and we can wrap this up here. Now, when it comes to training, like I said, this doesn't satisfy your comprehensive training requirements. If you want to serve as a coordinator, an investigator, decision maker, informal resolution facilitator, or appeal officer, you need to undergo a more comprehensive training specific to your grievance procedure. Now, all employees, though, they are required to be trained. They need to be trained when they are hired, if there's a change in their role that impacts their Title IX duties, and then annually thereafter. Your school needs to make sure that the training includes training on how to address sex discrimination, the definitions of sex discrimination and sex-based harassment, and when they need to notify the Title IX coordinator or chat with students about their rights. Thrun does have an awareness video that is available. So I would double check with your superintendent to see if that's something that is available for your staff. Key role training, again, it builds on that all employee training. And from there, it jumps to the grievance procedure, the informal resolution process, as well as how to serve impartially. All of these things are going to be required if you go through that key role training. Fortunately, we do have one training. We had one yesterday, but our next one is October 22nd. Okay, do we have any questions? I know we were able to answer a few of them as we were going through.
If there are any additional questions, you can pop those in the Q&A at this time. We'll wait a couple seconds here.
I know I threw a lot at you guys, but
there's a lot of great information. So we thank you, Jessica, for that.
Of course. And I will work on compiling that list and getting it over your way.
Absolutely. That would be great. I'm sure some of our administrators would love to see the list just to check if their schools are on
Yep,
that list.
absolutely.
So I don't see any questions at this time. I just want to thank everyone for joining us today. I do want to inform you to save the date. Our next Leader to Leader session is on October 3rd. We are going to be talking about developing effective AI policies in schools. So another hot topic. We have so many hot topics in our field of education now. So we definitely want to keep you abreast of what's going on, what pertains to you in your schools. Remember, all of these sessions are free for our members. You can always register at our webpage at masssp.com/events. And again, I just want to thank Jessica for being here from Thrun, our partner. We appreciate our partners in education who help us keep our members abreast of all these issues that are surrounding our field of education. So with that, I am going to wish everyone a productive day today. And again, remember, this information will be sent out to you via email as well as posted in our headlines.
All right. Thank you.
Thank you so much, Jessica.